Hi, I'm Mitzi Hill with Taylor English Duma in Atlanta, Georgia. I'm a technology lawyer with nearly 30 years in practice, both in-house and as outside counsel. In my current role as the head of our data privacy and security practice, I work with companies on their privacy compliance planning and on security efforts and the legal impact that those have on the company. And this includes everything from writing privacy policies to interaction with consumers who have requests about data to incident response. Virginia has a privacy law that came into effect on January 1st of 2023. It was pretty closely modeled on the first privacy law to take effect in the US, which was in California. And the Virginia law allows consumers to access, correct, and delete information that companies have collected about them. It allows consumers to opt out of profiling and sale of their personal information. It requires companies to offer consumers an opt-in option for processing of their sensitive personal data, and allows consumers to opt out of automated decision-making that might happen behind the scenes on a website in connection with advertising and marketing kinds of mechanisms. And for the covered company itself, the law requires that the company give very explicit and clear notice of what its data collection practices are, what it's collecting, how it uses it, what the consumer's rights are, how to contact the company to exercise those rights. It imposes on the company a limitation on only collecting as much data and the kind of data as they need to perform their services. And it institutes a really broad definition of personal information, which is kind of the key distinguishing factor of these new style privacy laws, because they are so broadly drafted and intentionally cover a wide range of information about individual consumers in order to give them some rights and protect their privacy. Virginia's law is unique from some of the other states and from California's because Virginia was among the first of the states to institute what's called an opt-in for processing of sensitive data. So in general, most companies in the US, even with these privacy laws, don't have to get consumer consent to collect and use their information. They just have to be very upfront and explicit about what they do with it. Virginia was one of the first to say, no, you actually need to get consent for this specific category of data and for in order to collect it and use it. And sensitive personal data that consumers are allowed to exercise this choice over would include things like religious affiliation, medical information, biometric data, things of that nature. The penalties under Virginia's law for noncompliance include investigation and targeting by the state attorney general and fines up to $7,500 for violations. There is no direct right for consumers to sue a company that violates the law. So again, I'm Mitzi Hill. I'm with Taylor English Duma in Atlanta. I appreciate your being here today. If you have any thoughts about the Virginia privacy laws or questions about how they may affect your business, please feel free to get in touch.